live. There's 41 people in the room, not including those who will be presenting. Thank you for joining us today for this fourth webinar in the ASA and SCAI webinar series. The subject today is how to draft effective dispute resolution clauses and how to solve them, solve those issues when drafting was poor. I am very happy to announce that we've got a lot of expertise, a lot of good expertise here today to address this topic, starting with Caroline Ming. Caroline is the Executive Director and General Counsel of the Swiss Chambers Arbitration Institution since 2015. She is a trilingual attorney, qualified in Geneva and New York, and has practiced in-house at SGS, Société Générale de Surveillance, and before that practiced as an attorney at Baron Carr in Zurich and at Piton Peter in Geneva. She's also clerked at the Administrative Court in Geneva and has studied, among others, with Professors William Park and Eric Green in Boston on the subjects of mediation and ADR. To date, she's worked in particular on the Swiss rules, with ICSID, ICC, and LMAA arbitration, and has represented parties in several successful mediation proceedings. She also serves as a board member in a hotel management group and in a pension and life insurance entity.
Good morning.
Also with us today is Manuel Arroyo, who's an international arbitration expert based in Zurich with Untitled. He acts as arbitrator and counsel to parties in commercial disputes. He's been practicing for almost 20 years in the field of international arbitration and litigation, and he is perhaps most well known for his magnum opus, Arbitration in Switzerland, the Practitioner's Guide, a 2-volume comprehensive treatise on arbitration in Switzerland, weighing in at some 3,000 pages. So without further ado, I'd like to give the floor to our speakers. We'll have a presentation for about a half hour, and then there will be an opportunity to ask some questions. Actually, that opportunity is there for you throughout the presentations. Please put your questions in the chat, and I will sort through them and direct them to the speakers afterwards. Just one comment about the visuals. Manuel is speaking from a conference room, which is why you see a split screen. You're not seeing double. That's it's just the way it is. But shouldn't be an issue. So I now hand the floor to Caroline to get us started with the presentation.
Well, good afternoon, everybody. I will focus the presentation on the experiences made in the last few years within the Swiss Chambers Arbitration Institution, but most of what I will say is actually valid for most other institutions, but I'd just rather speak about the one I work with than about the others. But most of it is valid. Don't worry about it. First of all, I would like to remind everybody that there is not just arbitration in life or just litigation. There are other services available, and most institutions offer various sets of services and rules. And you should consider using each set of rules in the appropriate time for the appropriate case. And you should actually use all of them, not for every case, of course, but you should consider the advantages and disadvantages of every type of proceeding when you make your decision how to most efficiently and effectively resolve the disputes of your clients or of yourself, of course, if you are yourself a party. The Swiss Chambers Arbitration Institution have been offering arbitration rules since 2004, and the Swiss Chambers of Commerce have actually done it for more than 150 years. The rules were revised in 2012. They're quite well known. They're still very modern and to the point. If for some reason you or your clients could not agree or did not want to use the Swiss rules of arbitration for the case or for the contract that was signed, you're not stuck. You have other options. For example, if it's a Untitled Clause or an ad hoc arbitration, or if it's an arbitration under another set of rules, for example, trade laws or the Swiss engineers and architects arbitration rules, you can still come to us to ask for our help for appointment of arbitrators, determination of costs and fees, administrations of funds. So we can be helpful for you. We have the rules of the Swiss Chambers Arbitration Institution as appointing authority in UNCITRAL or other ad hoc arbitration proceedings. Just for your information, these rules are about to be revised. We are almost final with a new text that will broaden up the scope of these rules, because we have noticed that we want to offer services to a lot of different types of proceedings, and also, for example, for ad hoc mediation, or as mentioned, the Swiss Engineers and Architects Association rules, or the 6 Swiss Stock Exchange rules of arbitration. They also ask us to act as appointing authority. So we offer a broad range of services aside or next, let's say, to the Swiss rules of international arbitration. In addition, we also offer services of case administration in mediation. We have the Swiss rules of mediation that have been revised last year. They are absolutely the most recent on the market. They take in account also the recent development with the Singapore Convention. They also try to push forward a few legislative evolution in Switzerland and in other countries. We are there, and with these rules, we are really up to date and have, I think, one of the best set available of mediation rules. There are also, if you are a financial service provider, a bank, for example, or an asset manager, we have dedicated services for you. We have the rules of mediation procedure for financial service disputes. This has been triggered by the new law that is applicable in Switzerland, and that is requiring you to affiliate yourself with an ombudsman or a mediation organ, and SCAI is one of them. So these rules are all available to everybody, not just, for example, these rules are not just for Swiss financial service providers. The 4 sets of rules are available to everybody who wants to use them, and I invite everybody to consider and to read these rules in order to take their decision how to best resolve the disputes, the present ones, and also the potential future ones. In terms of numbers, just to give you an idea, and the latest update from the Swiss Chambers Arbitration Institution, we already administered more than 1,400 cases, arbitration and mediation, 90% of which is international. It goes from Afghanistan to Zimbabwe. More than 122 countries have appeared in our database when I searched where do the parties come from. Of course, there is a majority of European, American, and Asian countries, but we also have African countries and South American and Australian countries. What is also important to know about arbitration in Switzerland and with the Swiss Chambers Arbitration Institution is that Switzerland has been neutral for more than 500 years now. It's a very stable and neutral place for arbitration. And it means that you will have less trouble if you come in Switzerland, if there are trade sanctions, or if there are political unrest in the countries that are affected by your contract. The expedited procedure has already been used for more than 27 years. Mediations are already, the rules are in place since more than 13 years. Emergency relief have been provided for more than 8 years. And just a few years ago, we decided to propose, and that's the most important for today's presentation, an automated, customizable arbitration and mediation clause. I'm going to speak about this one a little later. What is also important to know is that if you use the services of the Swiss Chambers Arbitration Institution, the proceedings will be 100% confidential. And this is very important in nowadays. You can resolve your dispute in privacy. And now I'm going to give you the main message that I want everybody to hear. If you leave early, at least you will know the conclusion. The conclusion, the safest and the easiest choice. If it's 3 o'clock in the morning, if you've been negotiating all night, if you have been given only 10 minutes or an hour to review an 80 pages contract, don't keep an old arbitration, mediation, or litigation clause that has been there. If it looks a little bit funny to you, react immediately. Choose an institution. Swiss Chambers Arbitration Institution or another one, fair enough. Choose an institution, go on their website, copy paste their model dispute resolution clause and put it in the contract. This is the safest and the easiest choice you can make. And Manuel will give you a few details, additional details later on about this. And why is this important? Well, because in the more than 5 years that I've been in the Swiss Chambers Arbitration Institution, I have seen so many bad and pathological clauses. And even today, I just received an email from one of our case managers who is attracting my attention on a clause and asking what we should answer. So we do spend quite a significant time answering questions with respect to pathological clauses, and that's why I wanted to make this webinar today. Here is an example that we received. It mentions the rules of the Arbitration Institute of the Geneva Chamber of Commerce. Well, there are a lot of confusion, and it is true that the Swiss Chambers Arbitration Institution, one of its members is the Geneva Chamber of Commerce, which in French is the Chambre de Commerce et d'Industrie de Genève, CCIG, which of course is a name that is very close to the ICC, in French, Chambre de Commerce Internationale. And since 2012, the arbitration cases are not administered by the Geneva Chamber of Commerce, but by SCAI, the Swiss Chambers Arbitration Institution. So there is a lot of confusion. There are a lot of names around, a lot of clauses that mention institutions that either do not exist or that actually are confusing, and it's not clear whether it is this ICC or SCAI or the Geneva Chamber of Commerce. It's important to give some clarity, and I'll try to give you a few points if you are facing one of these clauses. Another thing that is not good in this clause is that the number of arbitrator, the seat of the arbitration, and the language of the proceeding are not mentioned. So, of course, our secretariat will have to ask the parties. Hopefully, they will agree. If they disagree, then either the court or the arbitral tribunal will have to decide on these points. So if you want to avoid uncertainties, you should make this point clear in your clause. And this is what we do in our model clause. We do provide for the language that is to be used, and you just need to fill in the answer that you want to use. Luckily, and that's also one of the main messages I would like to pass today, this clause did not give rise to an endless, costly, annoying, frustrating dispute on jurisdiction, because respondent was clever enough to actually abstain from objecting to the jurisdiction of the Swiss Chambers Arbitration Institution as the institution that is now administrating cases that used to be submitted to the Geneva Chamber of Commerce. So when do we ask ourselves the question? Well, usually the claimant comes and files a notice of arbitration, and he has to provide us with the arbitration agreement or the arbitration clause, or to give us indication that there has been an agreement with the respondent with respect to using the Swiss rules and SCAI. The clause can be perfect or pathological. In any event, what we will do is our secretariat will transfer the notice of arbitration to the respondent and see what respondent answers. As mentioned already, some clever, cost and time efficient respondent do not object to the jurisdiction of our institution if the clause is a little bit pathological, but not completely. Or even if it is completely, sometimes they agree to change institution or to use us, even though it's a uncitral or ad hoc arbitration. So it is in the hands of the respondent. If the respondent defaults, or if the respondent does not submit, accept the jurisdiction of our institution, then the Swiss Chambers Arbitration Court will decide whether prima facie there is possibly jurisdiction, yes or no. And if it does decide that there is prima facie jurisdiction, it will let the arbitral tribunal make the final decision on this point. If prima facie it seems that there is manifestly no agreement to arbitrate, referring to these rules, to the Swiss rules, then the court will block the case at this stage. So if there is a pathological clause or if the arbitration clause is incomplete, either the parties agree together before coming to the Swiss Chambers Arbitration Institution. It happens sometimes. Some parties discuss about it before coming, and then they have a joint opinion as to what is the jurisdiction, and that is the most efficient way, of course. Or you can, as a claimant, you can try your luck, and hopefully the respondent will not object or will default, and the clause is close enough to a Swiss rules and SCAI arbitration clause so that the court decides that the case may go forward. But then you will be in the hands of the arbitration court or of the arbitral tribunal. The same is valid for the seat of the arbitration, the number of arbitrators, and the language of the proceedings if those have not been decided in the arbitration clause. It happens very often, as mentioned, that the institution is unclear. There is a lot of confusion between the Swiss Chambers Arbitration Institution, the Geneva Chamber of Commerce, or the International Geneva Chamber of Commerce, as some people think that it is called, and the ICC. So if it is, and we had a few cases like this, if it is mentioned the International Chamber of Commerce of Geneva, the court has decided that SCAI was competent and had jurisdiction. If it mentions the Swiss rules, then again, the court may decide that the Swiss rules and the Swiss Chambers Arbitration Institution have jurisdiction. However, if the mention is close enough to the International Chamber of Commerce in Paris, even though it might be written Geneva or Zurich, first of all, the ICC has offices in Geneva and Zurich now, but also it might be a reference to the seat of the arbitration. So depending on the wording, and I gave you here two examples where the wording was pointing more to the ICC than to us, and the respondent was defaulting or objecting. In these two cases, the Swiss Chambers Arbitration Institution Court has decided that we shall not administer the case, which actually means that the parties should refer to the ICC. In another case that was close to the ICC, it's a very recent one, the parties could have gone to the ICC, but the claimant submitted a notice of arbitration to us, and the respondent stated expressly in his answer, and it's also quite funny because even in his answer, he actually committed a few mistakes in the names, so that just shows how much confusion there is out there. He said that there are no objections to the jurisdiction of the Swiss Chambers of Commerce Association for Arbitration and Mediation. But still, we are now administering this case and everything goes well. Sometimes the named institution does not exist at all, like the international rules of the Geneva Court of International Arbitration. If it doesn't exist at all, but it seems to be something that is about Geneva, Geneva Chamber of Commerce, Arbitration Court, International Arbitration, since there are no other institution available, and if they file a case with us, it means that at least one party believes that we have jurisdiction, then the court may decide that the case may proceed. And here is another example that is similar, the International Commercial Arbitration Court in Geneva Chamber of Commerce and Industry. The name was close enough to the Geneva Chamber of Commerce, so this was accepted by the court. In one of the cases that I have seen in the last 5 years, the name of the institution was very clear. It was not the Swiss Chambers Arbitration Institution. The clause was very clear. It was a perfect clause. It was the model clause of another institution. But the parties changed their minds because they thought that there was a conflict of interest in this case because of some personal relationship between one of the parties and an employee of this other institution. And they decided to change institution and rules, and they came to us and switched to the Swiss rules of international arbitration. This is fine, provided the parties are in agreement. Another problem that may arise is the result of the decentralization and lack of legal framework for arbitration in a lot of countries. Almost everybody can start an arbitration institution. And in the 90s, a lot of lawyers started dedicated institutions and wrote their own rules. The group of lawyers, usually they created an association. These lawyers have grown older, and the number of cases was not that high that it was worth keeping the association or the institution open with a secretariat and everything. We, for example, we administer about 100 cases per year. If you have less than 100 cases per year, then it's hard to have a professional secretariat available every day to administer potential cases. So we made an agreement with two associations based in Geneva, the International Commercial and Industrial Arbitration Association and the Association for Arbitration of Commercial Lease Disputes. And these two associations have decided to not administer arbitration and mediation cases in the future, but to delegate the case administration to SCAI and to ask SCAI to use the Swiss rules. For your information, the ARICI, the International Commercial and Industrial Arbitration Association, is about to be closed in a few years, but they didn't want the party to be left in a risk of denial of justice. So they wanted to ensure that the parties who had entrusted them in the past, even in the future, even if they have a case in 5 or 10 years, that they have a solution. And they chose us as the place for the arbitration. And now I will pass the word to Manuel Arroyo. Manuel will speak about a few of the cases that he has been advising clients on in the recent years.
Thank you very much, Caroline. Yes, indeed. The term pathology, of course, usually goes to the core of the clause itself, usually affects the language, the wording. So I've started, I will just bring 3 examples. And the first one is a classical one where you have really bad wording. And here the parties to an agency agreement, the match agents from the UK, which were our clients, they concluded an agreement with a National Football Association from Asia. And the dispute resolution clause stated FIFA shall be the sole arbiter. The Latin term arbiter was in it, which actually saved our case because we could convincingly demonstrate that the parties agreed in arbitration. At the same time, FIFA is of course not an arbitration institution, an arbitral institution, nor is it an arbitrator. So there was all sorts of discussions. In particular, respondent submitted that the parties didn't want arbitration. They actually wanted conciliation. So there was a lot of historical filings on the meaning of the word arbiter in Latin, etc., etc. The point I'm trying to make is that this became a mess. Ultimately, it was an ad hoc arbitration. Ultimately, the tribunal found it had jurisdiction, and rightly so. not just because that was my submission, but because arbiter actually points more to arbitration than to conciliation, a sort of mediation. So that was the point I wanted to make here, which a flaw really going to the wording. If the parties had acted like Caroline just said, this would never have happened. They could have chosen Swiss rules, SCAI arbitration, and there would not have been an issue on this. Now, I have trouble moving the slides. Could you move one? Thank you. This is another dispute on the dispute resolution clause, which was an insurance dispute, and the next two examples are inconsistencies. So what I mean is that the wording of the clauses, dispute resolution clauses themselves were good, were fine, but there was an inconsistency within one contractual framework, within two interrelated contracts, two connected contracts. And the insurance dispute here was that, as you know, there is the insurance binder, the so-called binding insurance slip, where the parties agree that a given insurance policy will be issued. They also agree on the main terms, the coverage in particular, etc. And then subsequently, usually, the slip is concluded or agreed on, the insurance binder, in December, and then the next year, for the next year, you have the insurance policy. Now here you had two different dispute resolution mechanisms. You had, on the one hand, State Court Litigation Zurich on the insurance binder, and then on the insurance policy it said SCAI Arbitration Geneva. So the problem really was that the respondent, not like we all would hope, said, of course, the insurance policy is the main document, the overriding agreement, but insisted on state court litigation and created a whole mess. What you will have in this kind of case, in all three examples, is you will have an arbitration within the arbitration. You will have an arbitration, a dispute on jurisdiction, when in principle the arbitral tribunal should be deciding the merits of the case. But in some cases, it's one party is making a fair point, the respondent, but usually it's obstructive. They're just acting in bad faith, like in this case. Obviously, the parties agreed on arbitration because in the main document. And then if we move to the next slide, Caroline, this was also major incident. Probably a fourth of the costs, which were very high in this high-scale settlement dispute, were only on jurisdiction, because here you had a very complex settlement agreement. Okay, two parties were in dispute. They settled the whole dispute. They agree on everything, but then there's a big dispute on whether or not the claimant later in the arbitration has to first pay back the 80 million in cash, or the respondent later in the arbitration has to give first back the promissory note in that amount. They didn't trust each other at all. And in the contract, it wasn't established who has to move first. And Swiss law doesn't provide for a solution on this issue. And so we came up with a lot of potential solutions. For example, have the arbitrators act as escrow agent, or take an independent escrow agent who would then receive on a given account the 80 million and the promissory note, the hard copy, the original, and then hand it over to the parties. Respondent did not agree to this. It was a big jurisdictional issue, many submissions, a lot of money and time wasted. And finally, because you see the problem in this case was the main agreement, it had an arbitration clause. This is why we initiated the arbitration. But in the annexed contracts, you had a lot of, on collaterals, on a medical center, etc. You had state court litigation. This was, of course, a big mistake the M&A department of that firm made. And I will come back to the M&A department and the private client department later, but here also a big mess. And this is why use the model clause, like Caroline said, and in case you have multiple connected, intertwined contracts, make sure one and the same clause is used in each contract. Can be arbitration, can be ArbMed, It can be anything, but just use the same one always, because otherwise you will have a major incident. And with this, I give back the word to Caroline. Merci.
Thank you very much, Manuel. So how should you draft effective dispute resolution clause? Of course, most of the participants today are lawyers or maybe law students. You want to be active. You don't want to just make a copy paste. I understand this. So first of all, start by the copy paste, especially if you are young. Especially if you have language issue, start with a copy page, and then you can, of course, try to be smarter in the adaptations. There are new trends. There are certain countries and certain jurisdictions have a tendency to overcomplicate things in the contracts. When I was a lawyer in the legal department of the Société Générale de Surveillance, SGS, we sometimes received contracts where you had 3-page long dispute resolution clauses. One of them was really interesting. It said it had multiple layers of negotiation and mediation. And in the end, if the parties did not find an agreement after they had the technical people speaking, the business people speaking, the two CEOs speaking together, then in the end, the CEO of the other company was going to be the arbitrator and would decide on the case. This was one of the contracts where I said to my colleagues that this was a big no. It was one of the only no's I said in more than 9 years that I was at SGS. I said, this is a no-go, especially in the country where it was, where we already had other problems with local courts. As mentioned, what is important also is that the clause must fit within the chosen rules. So you choose first the institution, then you take their model clause. Don't take our model clause and try to put the name of another institution, and vice versa. Don't take a clause recommended by another arbitration and then suddenly put half of our name or half of the name of the Swiss rules, because you may encounter problems in terms of jurisdiction, but also in terms of interpretation of the agreement. So choose the institution, then pick their clause, and then adapt and fill in what is asked. You can also, most of the institutions provide for med-arb clauses or arb-med-arb. We made the exercise. It works with the Swiss rules of international arbitration and the Swiss rules of mediation. You can make arb-med-arb. I have myself drafted a clause and I submitted to a certain number of our colleagues. It works. However, it is a little bit complicated. And so we decided not to provide it to parties because we are too afraid that the parties would change the wording and that in the end it would create a huge mess and that it would become more problematic than anything else. So you may draft your own clause, but you can make arbitration mediation and arbitration arb-med-arb if you want with the Swiss rules. It works, it is possible, but we will let you the responsibility of drafting the clause. And I just put a few caveats. Beware of the ways to deal with non-participation of respondents. There is no point in going in mediation if there is no respondent coming to the table. And make sure also there are clear cutoff points between the different phases, and decide whether the mediation should take place before or after the arbitral tribunal constitution. Another new trend is automation, and for this, SCAI has a very nice clause. This is a standard arbitration clause and mediation clause of SCAI. It's not a med-arb. It's the normal arbitration clause. What is important for whatever the arbitration clause you are drafting, write arbitration in full, not arbitration. Mention the rules, mention the institution, mention the number of arbitrators. I personally like the answer 1 or 3, because when you draft a contract, It can be a small contract, but the dispute might be huge, or the contrary, it might be a very large contract, but in the end, the dispute is a small one. So you may want to have the flexibility. And yes, under the Swiss rules, depending on the case, the parties and or the court have the possibility to change the number of arbitrator that was decided upon in the arbitration clause, but it's not always easy to do so. So if you put 1 or 3, I like this answer, then everything is open. And once we know what is the dispute, then we can make the decision what is best, 1 or 3 arbitrator. It makes no point of having 3 arbitrator if the respondent is defaulting and the claim is small. With regard to the seat of the arbitration, there are 2 points. First of all, if you use the Swiss rules, but it's not the case under some other rules and in some jurisdiction, but if you use the Swiss rules and if you are in Switzerland, the seat of the arbitration does not determine the seat or the place of the hearings. You can still hold the hearings somewhere else that is more convenient if you wish. But the seat is important to determine what are the courts available to provide support to the parties in case there is a problem, and also for setting aside proceedings. So the seat is important. It should not be your next place of vacation. Another point is the language. When I was a lawyer at SGS, we often had cases, for example, in Africa, in French-speaking Africa, but we made the contracts in English because the templates were in English. So there, we used to say that the arbitral proceedings shall be conducted in English because the contractual documentation was in English, but then we would say that evidence could be accepted in French without translation, for example. This is something you can consider if you want to add an additional feature in your clause. What I really like in this clause is that it provides for mediation anytime. So it's not a mandatory mediation before the arbitration clause. It is anytime. And mediation is particularly useful either before starting the arbitration or in the middle when the parties are getting frustrated and anxious, or even at the end where they are even more frustrated and even more anxious, sometimes even after, if the decision that was made is not pleasing one of the party, but they still need to work together in the future. If you want to restore the relationship, you could even have a mediation after the issuance of a arbitral award. So I particularly like this clause. Another feature that I really like in the Swiss Chambers Arbitration Institution is the customizable automated clause. We help you. If you want to proceed faster, if you can consider proceeding without hearing and on the basis of documentary evidence, we provide you on our website with a clause that is allowing you to pick various options and to combine them in order to have a faster arbitration proceedings in case you have one. And the system, in the end, depending on the answers that you give, the system will create the clause for you. And we have this clause in various languages, so you may want to have a look to our website. And just one more point, there was a case law a few years ago in Switzerland about what happens if the parties do not properly come to a mediation before going to arbitration, if the mediation clause was mandatory. Then the Swiss Tribunal Federal decided that the arbitral tribunal should suspend the proceedings and fix a time limit for the parties to attempt to settle their dispute. I quite like this decision as well. And how to solve the issues when drafting was poor, I gave a lot of answers before. You have to consider applicable laws, jurisdiction, whether you need provisional measures, and if yes, is it against a third party or is it against the other party? Do you have a problem of time bar? Beware, because mediation, introducing a mediation request may not block the time bar deadlines. So you may need to file for arbitration or litigation just to resolve the issue of time bar, even though you want to use mediation or to continue negotiating. You may also want to consider lis pendens or obtaining a case law, a published precedent when you decide if you go to litigation or arbitration. Confidentiality, this is an important point, and if you decide on an arbitration institution, and the rules, choose the ones that have the confidentiality rules or that provide confidentiality services. This is something you may want to check. There are different opinions on the subject. And then analyze your case fully when you make your decision. You can always change of mind. Negotiate with the other party is the key of efficient dispute resolution, efficient and effective. The more you can negotiate, the faster and the better. Of course, you can also consider litigation, arbitration, mediation, or also we used to do that sometimes. We did nothing. Sometimes you just wait and the issue somehow disappears because parties have other things to do, or because actually they find the answers later on or discover that there was a misunderstanding somewhere and they drop the case. So sometimes doing nothing is also an option. As mentioned, when you have a dispute, even if you have a pathological clause, consider an agreement, a specific agreement when the dispute is there. You can change the institution, you can change the rules. You can also hope for the implicit consent or the absence of objection by the respondent. Or you can use, if you don't want to use the Swiss rules for various reasons, this is very understandable. You can ask an institution, not only SCAI, other institutions also provide for appointing authority rules or supporting authority rules. Check what is available as support. And you can also use the Swiss rules of mediation or other sets of rules. As I said, not only before arbitration or litigation, but also during or in parallel or at the end or even after the issuance of an arbitral award. With this, I will open the floor for questions. And I will let Manuel answer most of the questions because we were aware when we prepared that I would speak more. So I will now allow Manuel to speak more. But if there is any specific question that is really for the institution, I'll be happy to answer.
Thank you very much, Carolina. Just before we started the discussion round, I mean, just to wrap up the essence of what you just presented is that it's like generally in life, it's easier to avoid a problem rather than try to fix it, especially if a respondent is obstructive or not willing to negotiate. And also, you said rightly that if one is young, one should go to the model clause, or also, of course, if one is in a hurry, or both, young and in a hurry, or more generally, whenever you have to include a dispute resolution clause, make sure to get either expert advice or use a model clause. And to those of you joining us today who are at a law firm, this would include also, implementing a protocol within especially the M&A department and private client department that whenever they conclude a contract, they have the litigators and arbitrator practitioners check that clause and give a green light or have it amended. And also the same holds true for corporate entities. Those of you who are in-house counsel, and those of you who have experience in litigation or arbitration will be able to do this themselves, but otherwise always get expert advice on the litigation clause or arbitration or med-arb clause you want to include. And yes, we're interested in hearing your questions. Thank you.
Okay, so I thank both our presenters for their comprehensive contributions to the issue. We have a number of questions. One of them addresses the issue that I think everyone's aware now of the number of options that are available through the use of whether it's arbitration or ADR, mediation and the like, and that this buffet of options is appealing in certain cases, but too many options are not something you necessarily want to add in the arbitration clause itself for want of making it confusing. We have one question that addresses a little bit the issue of selection of different parts of a contract or different disputes within a contract, provided that no dispute on the competence of SCAI is present. How would arbitration be impacted if arbitration is the selected method of dispute resolution, but with regard only to some or even only one of the contract's clauses? And maybe related question, we heard from you that if there are multiple contracts, they should all have the same clause. Do you have any experience with a overriding language in an arbitration clause, much like we might see with respect to a contract, a newer contract that overrides any preceding contract? Something along the lines of this arbitration clause will supersede any others affecting the parties or binding the parties in case of conflict. So I'll put those questions maybe first to Manuel.
Well, in long-term contracts, you do have this kind of wording, especially if the parties have been doing business for 50, 60 years, and then you make a new contract every 5 years, for example, even though, I mean, if assume you always have ICC arbitration clauses, and then suddenly the parties in the newer one include a SCAI arbitration, I mean, Swiss rules arbitration clause. Normally, I mean, under Swiss law, of course, but also under most laws I know, the interpretation methods would lead to the conclusion that the parties now want SCAI to administer any dispute under this contract. Of course, you might have an issue if it's an all mining dispute and the timeline goes back. The initial problem, for example, in mining started, the causal nexus started under the previous contract providing for ICC arbitration, but the exact damage, the damage occurrence only happens during the new contract, which is a Swiss rules arbitration. There you run into problems. But this is, I think, a very particular case where you will have a causal nexus of 7, 8, or even 10 years. But usually, I mean, the newer contract overrides the old one. But of course, it doesn't harm or is actually helpful to say, okay, this now supersedes any previous contracts. This is the only contract, and especially also with regard to dispute resolution. I would say that would be a reasonable approach, I believe.
Yeah, I agree. It's very complex and every case is very different. So I don't think we should go much further into details. I can, however, give you one example where there could be a problem. It is, for example, in Turkey, I learned that in Turkey, if you make an arbitration agreement, you have to have special authorization for it. So only certain levels of the hierarchy in a company can have these specific powers to agree to arbitration. So if in a later contract, a young legal counsel decides to change the arbitration clause, then in this case, it might be different than what Manuel said. And then maybe the first arbitration agreement or clause would actually stay and the second one would be disregarded. So in every jurisdiction, in every case, it's so different that I am a bit reluctant to go too much into detail. But it is certainly a problem. And it goes into interpretation of the intention of the parties and the applicable law and the jurisdiction.
Okay, thanks. We've got a question about expert determination or adjudication, which just really highlights some of the possibilities available in ADR. One of our attendees proposes a scenario giving a window of 28 days for online binding expert determination for a proportion of the value of the contract, followed by mediation under the Swiss rules for 14 days. and then followed presumably by arbitration as a possibility. We also have a question
what is the question?
It's more of a comment which I'm sharing. Although there is a related question about whether or not in the future the Swiss rules will provide specifically for expert determination or adjudication. So if you've got information to share about that, please do.
Not for the moment. It's of course something we are sometimes discussing.
But I have something. I have something to add there. I mean, what I often see is also in M&A contracts. If you have, for example, you have a dispute resolution clause, and I like the 14 days you mentioned, for example, where you say if the parties get into a dispute as to whether there was the occurrence of a major adverse change, for example, the factory building that is one of the assets or the main assets of the M&A deal burns and is destroyed, then who is to determine whether or no that was a major adverse change? And then I've seen, and I've also recommended that this be someone, I mean, this is usually then ad hoc, but you already determine the arbitrator in advance when you sign the contract, and you say this dispute will be determined by this gentleman, and ideally you also choose other persons in case that arbitrator could not act. You ask number 2, number 3, number 4, number 5, and in case it's like a cascade. In case one has a conflict of interest, the other no longer works or is retired, etc. And then you will have a resolution of that dispute, that key question for the parties within 14 days. Of course, that's also super expedited because usually we just have 1 day hearing, everything is submitted, and usually that's ad hoc because it just has to be done very, very quickly. But this is this is something you could also think about.
Yeah. And with respect to speed, it depends what is the relief that you are seeking, because you could also consider the emergency arbitrator provisions of the Swiss rules, and the emergency arbitrator has 15 days to render his decision. So, and if it is against a third party, then you have to go to courts. So there are a lot of tools available. SCAI is providing a certain number of tools, but not all of them. What I think is really important, and I know that there are some students listening to us today, I think what is really important is that you not focus only on arbitration and only on 1 or 2 institutions, but that you really broaden your mind as to what are all the tools available, what are all the systems and rules, features available, and that you are then able, each time you have a case that will each time be different, to pick the right tool, the right set of rules, the right institution for that particular case. And that you are also flexible enough in your mind, even if you have a perfect clause that provides for arbitration under XYZ institution and rules, that you keep your mind open, and whether that might be another option. As mentioned, for example, in Switzerland, we have less problems with trade sanctions. So we have sometimes parties who have in their contract an arbitration clause that is a very good one for another institution with a seat outside of Switzerland. But because of the trade sanctions, they have problems to paying the arbitrators, to paying the institution, to even be allowed to proceed with an arbitration. And sometimes they do come to us. So every case is very different. What is important is that as a lawyer, as in a house counsel, you have in your head, all the tools available present in your mind, and then you pick the right one and you change of tool when necessary.
Okay, we're coming up on the hour, but I think we've got time for one more question. would the speakers recommend including just a term for negotiation between the parties prior to being permitted to file for arbitration, or is a mediation clause to be preferred?
Well, personally, it's two questions. The negotiation question, no, I would not include that, because the parties can negotiate anytime anyway. I mean, I've seen many arbitrations where the parties say, stay the arbitration, please, joint submission, stay the arbitration for 2 months. They try to settle the dispute. Sometimes they are successful, sometimes they're not, but I would not make that a requirement. And the other question, mediation, well, yeah, you can include it, med-arb. It's just very important that you say how long do you have to try to mediate or negotiate, because otherwise you will have a dispute as to whether one party acted in good faith or negotiated in good faith long enough. So it's very specific. I mean, personally, I think the parties are always free, and also under the Swiss rules, to say, okay, now we take this to mediation or negotiate a settlement. They're free to do it. I just wouldn't put too many requirements into the. I mean, if one wants to shoot first, let them shoot. And initiate the arbitration. And you know, sometimes it happens also, and I'm sure Caroline can confirm, that you get the request for arbitration or the notice of arbitration, which initiates the arbitration, and then suddenly the other party, who for 6 months didn't want to negotiate or sit at the table, says, no, wait a minute, please file a request for a stay, and let's try to settle the dispute. So sometimes it takes that initial shot for a respondent to come to the negotiation table. But of course, this is very much from the litigation perspective, and yes, but that's my personal view, and it's my recommendation to clients usually.
Yeah, I have seen all types of situations, and also sometimes some lawyers are actually themselves of pretty bad faith, or sometimes they are too junior and they don't negotiate. I've faced an arbitration where I said, why didn't you come negotiate? Why am I made aware of this case only when we receive the notice of arbitration from the Secretariat of the ICC? And he said, oh, but no, we wanted to start the case. And I said, yes, but we could have discussed before, because we are going to settle anyway, because with what I'm going to tell you, you're going to settle. And this is exactly what happened. So it's a pity when the parties do not negotiate in the beginning, and if they do not require the business people to bring in their in-house counsel. Because my business people at SGS, they knew about the case, but they did not bring me in, because they thought that they could resolve the issue on their own. So I could see why in some very few cases a negotiation step could be useful, but in reality, no, it's more education of the lawyers that would be useful, I think. And in terms of mediation, I think this is a really useful tool, because the mediator acts as a facilitator, and every lawyer thinks he's an excellent negotiator, but actually, and even I saw that myself being educated in mediation, what I say as a party is not listened to, is not believed by the other party. So even though I might make some suggestions in terms that actually a mediator would do, if it comes from me as a party representative, then it doesn't work. So the use of a mediator or a facilitator is of great help to enhance the communication, to uncover misunderstanding. It's a very useful tool, and I really like this clause that was actually invented 2 years before I joined SCAI, with the mediation anytime, not necessarily before the arbitration. And but it's mentioned in the clause, and like this, the parties are going to consider it when they have their dispute. It's facilitating the discussion about that point without having this impression that, oh, they suggest mediation because they are weak, they have a bad case, they want to settle. I hear this very often. It's not true. I think that a party who suggests mediation is a party that is very clever, that is cost and time conscious, and that also takes care of the interest of its clients.
Okay, thank you. I'd like to thank our speakers. I think on behalf of all of you who are online and can't do so personally, this is very useful information. Just a note, I've had a number of questions as to whether or not the presentation will be shared. It will be. This webinar will also be available online on the ASA and on the SCAI websites. So for any of you who might have missed something, or if there's anyone you think might wish to explore further or might wish to hear what's been said, please direct them to our websites. And thank you again for joining today. This series will continue with other topics, so please check back again on our websites for future topics, and we hope to see you soon again. Bye, everyone.
Thank you so much.
Bye.
Bye-bye.